Hello, YouTube. I'm Vince White. I'm an employment attorney on this channel. We answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here from YouTube user David Settle, who asks us, are Court of Appeals cases hard to win? Okay, David, I'm going to assume what you're actually asking me is an appeals case difficult to win. And I'm going to give two answers. First and foremost, every appeal is different. If you have an amazing appealable fact that is clearly appealable and that you should certainly carry the day, then no, your case is not difficult. Your case will be very compelling to the appeals court, to the appellate panel or the appellate judge, whoever you might be in front of, and it will likely carry the day effortlessly. That being said, a clear-cut, easily appealed question of law or procedure is not the most common thing. Most appeals depend on esoteric, finer points of the law that may not have been considered yet, or may have been considered improperly or not improperly, depending on who you ask, by the judge or arbitrator who saw your case. So, generally speaking, here's the lay of the land on an appeal. You've already lost something. Maybe you've lost your case. Maybe you've lost a motion. Some hearings, some discovery decision, whatever it is. You've lost something, and you've already lost. This is a key thing that people don't understand. If you are pursuing an appeal, it's because you've already lost an argument about something. And coming back to win an argument after you've already lost it is more difficult than winning it the first time. Almost always. Almost always. Unless there's something really sketchy going on with your decider, your judge, your arbitrator, whoever it is. Now, let's add to that many appeals courts have very, very strange, very arcane, very complex procedures made to drive up the costs for getting an appeal filed. So now you've already lost. Fighting that loss is going to be very expensive, with many opportunities to fail if you don't hire a seasoned professional. And you're under the gun time-wise. I think you can hear, inherent in that, the difficulty that a plaintiff can experience when filing an appeal. Now, defendants, they also have difficulties when they file appeals, but they're fewer. Often they will use appeals to buy time, to delay payment. There's a lot of things defendants use appeals for because they are less cost conscious, right? If you hire a small employment law firm and let's say you lose one key valuable claim in your case, they can still go to the trial on the rest of your claims, but they lost, or you lost, you together with your firm, lost one of the more valuable claims. And now you think your case is worth a fraction of it was before because that claim is not going forward anymore. You may want to appeal. But that firm might say to you, hey, our retainer does not include appeals. Like, we have a case we can go forward on. We're not going to back you to the 80 grand this appeal is going to cost. So if you want to file the appeal, you go right ahead. But there's not really too many contingency-based appeals attorneys. People will call us and say, hey, I need an appeal on contingency. And we say, oh, yeah, that's not going to happen. Because you have already lost and you've introduced a great deal of risk. So the idea of doing an appeal on contingency is a non-starter. Further, if you win the appeal, you don't necessarily win the client money, right? Most situations you don't. If you win the appeal, you're only going back to the original court having been vindicated on that one point. Generally speaking, the appeal will not usually mean that you've now won the case, right? The trial, the underlying trial in the underlying court will still have to go forward for you to win. So doing an appeal in a contingency of what? A percentage of what? What is that attorney going to take a percentage of? They're going to get your case back to the undertrial, to the trial court, and then wait for some other firm to hopefully win that case so they can take a piece of a case that the other firm is already taking a piece of. You can hear the difficulties in that economic proposition. Appeal attorneys are going to say, yeah, tempting, but I'm going to go ahead and say no thanks, as they rightfully should, right? Now, by the same token, there's certainly firms, we've done this, where, a piece of a case that we don't agree with gets decided incorrectly, right? It's just, listen, we think this is a crowning jewel, this claim is amazing, and a judge threw it out, and we think there's, some real appealable questions there. We'll fund that appeal. We don't do it ourselves usually. We usually farm it out. But we'll get a real appeals attorney, one we know is very good, who we use all the time, and have them do the appellate work on that to get that restored to the case, because we think it's the crown jewel of the value of the case. And if we're going to be spending a lot of money on this case, taking it to trial, we want to have our crown jewel in the case to better our chances of recouping what we're spending on the case, right? But that is a luxury that we have because we have a larger than average war chest. We're very fortunate in that sense, right? We've had a good run. And a lot of people want to hire us. So that's something we can do. I'm going to be honest with you, I don't believe most firms, most small plaintiff side employment law firms, I don't believe they have that luxury. Or if they do, maybe they can afford it once every couple of years. I'll be frank with you, I don't think I could have afforded it 5 years ago. Which is funny that I say it because I think I actually did it 5 years ago. But it was terrifying. It was a stretch. It was tight. We were strapped. We spent everything. We were pulling the copper out of the bathroom and selling it to fund that appeal. You know what I mean? It was a scary time. But we believed in the case desperately, and we went for it because there was a question that we felt was incorrectly decided that didn't exterminate the value of the case, but did gut it to some extent. And we needed to get that value back, or the case was never going to end up in the green, right? There wouldn't have been the ability to win enough to make that case worthwhile. So David Settle, yes. If you have to consider whether or not to file an appeal, that is a weighty and difficult decision to make. It is pursuing an appeal is incredibly challenging, incredibly expensive, often incredibly high risk. And I can only commiserate with you and say that I'm sorry that is something you're wrestling with right now. But I wish you great success. If this video is helpful, like, subscribe, and comment down below. Share our channel so I can grow. Take care.